Seek your indulgence in mentioning item number 16.
For orders.
Hearing, my lord. Today list.
Today's
one.
list,
Yes.
item number
16, my lord.
16. Okay, yes.
Lordship, if this matter may be taken up after the ensuing vacation.
Is your name here in the cost list?
No, my lord.
Okay.
I'm on behalf of my senior.
So mention is made on behalf of Mr. Johnny L. Tochong, learned counsel for the appellant, for adjournment of the matter with the counsel, which is not objected by Ms. Vane Isyami, learned additional PP. In view of the above, list the matter after the vacations. Yes.
Much obliged.
For admission, item number 1.
My lord, I have filed my additional affidavit in this regard, my lord. I have given the updated status of the construction of different jails. in
Okay,
different
jails. Yes, yes, yes. So let's see photographs also.
Yes, my lord, the
enclosed?
photographs is also enclosed. At page number 4, this is with regard to the work related to Central Jail Aizawl.
Okay, Central Jail, construction of now the administrative building.
Yes.
Last time,
This has
the
not
last time which I visited, that was, no, I think it was end of last year, was the ceilings. Okay, they were starting to crumble, the administrative building.
All right.
So I think you have to start your work as early as possible. Some of the buildings, and we were jokingly saying that we have to be very careful, otherwise the roof could fall on us.
Yes.
Okay. Anyways, so yes, so the remarks is, it is planned that demolition, it has to be demolished. It cannot be renovated also.
This will be undertaken following the completion of the internal works
Okay, mail,
and the
The
vertical
mail
extension of mail word.
what's construction
Work in
of
progress.
work not started. Okay. Construction of MI room, Central Jail, work not started
Work has
yet.
not started yet.
So when do they plan to start the work?
My lord, they are doing step by step, my lord.
Okay. But so how much has been allotted? The amount that has been allotted specifically for the Central Jail? Any detail on that?
My lord, I have no details regarding the the fund
Find out
allotment.
how have you broken up the sanctioned amount? How many crores was it?
Lordship, 13 crore 50 lakhs.
35, yes.
Okay,
But that is for the whole,
that is for all the
Yes, for the
Central
whole
Jail and all the
project,
district jails,
yes.
isn't it?
Yes, Lordship.
So work not started, so how have you broken up the, is there any more constructive plan as to how is it?
that
How
has
much
not been mentioned yet, my lord.
amount has been allotted for Central Jail? How much for what's this, Lungday? See
I'll
how,
try to get instructions in that regard, my lord.
okay.
And, my lord, I'd like to make one submission. There are as many as 8 contractors working in different districts.
okay,
So if these 8 contractors may be implemented as a party so that they can give updated status, my lord. Otherwise, it
I
becomes.
have no objection to that,
okay,
Lordship.
then we will do that. We'll pass an order accordingly, find out who the contractors are.
Yes, Lordship.
Then they can also update us, and also the breakup of the
Yes, yes, I'll try to
whole
get
amount, so that we can see,
Yes.
isn't it? We will be able to monitor it even more
As
in
far,
detail with the amount. Yes.
by now, my lord, almost 50% is completed. That is the verbal instructions that I have received.
Then it's still very less. Work not started for most of the, work not started, but 50%. Then we'll have to see how the money has been, broken up into how many, this thing for which jail, how much, and what is the amount, 50% in which jail, whatever. Isn't it more details?
More detail.
So maybe the concerned contractors, if they are implemented, they can give us a better detail of the works. Yes, okay. I heard Ms. Rosalind Elmer, learned counsel for the petitioner. Also heard Ms. Linda L. Fumble, learned additional AG for the state respondents. Full stop. The learned additional AG has filed the affidavit showing that construction work has started in this central jail and the district jails, and the status of work progress in the jails as on 25/09/2025 has been enclosed along with photographs. We have perused the progress of work and the remarks attached and the remarks made in their respective columns regarding the works and the progress, and we have also perused the photographs enclosed. We find that there is some progress in the work for the renovation and reconstruction of the jails. However, we have noticed that there is no details as to how the sanctioned amount of how much?
55,
Fif-
sorry. Yes, Lordship, or altogether, the sanction was 55 crores.
Okay, 55 crores have been broken up and to be spent on the respective district jails. The learned additional AG may get instructions and file an additional affidavit highlighting as to how the sanctioned amount has been broken up for the each district jail. Good stuff. The learned additional AG also submits that as many as 8 different contractors have been assigned for the reconstruction / renovation of the central jail and the district jails, and it might be necessary for the proper monitoring of the works done to include the said 8 contractors. Full stop. We have considered the submission and find it appropriate if the learned counsel for the petitioner should get the names of the said 8 contractors and file an application for including the said contractors after getting the necessary details. List the matter after 4 weeks.
If I may say one thing, Lordship, the affidavit submitted on 4th December 2024, a letter dated 2nd September 2024 has been annexed, and here they have submitted overall abstract cost of the
Okay,
estimate.
it's already there. You
Yes,
didn't know.
Lordship, if this
Okay.
can be finalized, Lordship.
Okay, it's just the abstract cost. Where is
Yes,
it?
Lordship. 4th
Affidavit
December
dated?
2024, additional affidavit submitted by the state, Lordship.
For December. Yes,
From page 8 onwards, Lordship, abstract costs of District Prison Marmit, Serchip, Champhai, Kolasip, Seha, Aizol, Lunglei. All these abstract costs has been submitted site-wise as well.
okay, so in the previous paragraph breakup, okay, that paragraph breakup of the cost, okay. It is also seen that the abstract of cost for the district jails was filed in the additional affidavit filed by the state respondents on 04/12/2024. The final breakup of the cost for the repair of the district jails is also to be, filed in the additional affidavit. I'll make a few improvements. Just after, we'll make it 3 weeks by the time.
After vacation.
Pledge, Lord.
Item number 2.
It pleases your lordships. As per the last court date, my lord, I have submitted that I have prayed for extension of the validity of the contract period to up 15/12/2025. The prayer was allowed, and the office of
Where's
the,
the thing letter? Yes.
yes, it has been extended up to 31/12/2025, and I have submitted the document, my lord, the extension order.
Okay, Ms. Lorozen Elmore, learned counsel for the petition is present, along with Ms. Valentina K. Dingpui, learned counsel for the respondent's number. You're for the
Respondent
respondent's
number 1, my lord.
one, and Ms. Linda L. Fumble, learned additional AG for the state respondents. The learned counsel for respondent number 1 submits that that the request of respondent number 1 to extend the validity of the contract period of work for the construction period of the work, then within inverted commas, construction of double lane BUS Gridder Bridge, open bracket 102 M, capital M, span, close bracket, over R Terre at CH 7.00 KMP on Bhairavi dash Zamwang Road, close inverted commas, has been granted up to 30/12/2025.
31, my lord.
31/12, isn't it?
Yes, Lordship.
2025. Good stop. In view of, she therefore prayed that they would be able to complete the works within the period granted. Full stop. In view of the above, list the matter immediately after the ensuing vacation.
Obliged, Lordship.
Much obliged.
Vacations, then a copy of the said letter dated 25/11/2025 is to be marked as X and made a part of the record.
Item number 3.
Lordships, in item 3, I appear for the petitioner. Your Lordships would recall we are challenging the rule which is directly contrary to the Act. And also, several dates have been, the matter has been listed.
Yes, Your Lordship, in this regard, in the last court date, I was given a last chance to submit the affidavit. But however, Your Lordship, as per my information, now the consolidated parawise comment is with the law department for vetting. So I'm seeking another 2 weeks' time, Your Lordship, to file my affidavit.
With utmost respect, Manoj, this was the reason given several times, Manoj,
Okay, with cost,
with cause.
okay, 5,000.
Yes, Your Lordship.
Okay, Mr. Jordan Rupinthanga, learned counsel for the petitioner is present, along with Ms. Vani Siami, learned government advocate for the state respondents number 1, 2, 3, 4, and 6, comma, Ms.
My Lord, I'm appearing on behalf of my senior for respondent number 5.
Okay, Ms.
Daphne Leshuetwang.
Daphne Loshiltoni, appearing on behalf of her senior, Ms. So-and-so. Your senior's name is?
Jessida Nunsanga.
Oh, J. Silal Nunsanga, learned counsel for respondent number 5. And Mr.
Stephen Lalbuat Saya for respondent number 7.
Stephen Lalbuatsaya, learned counsel for respondent number 7. Full stop. The learned government advocate has prayed for further 2 weeks' time to file their counter affidavit by submitting that the matter has been vetted by the law department and can be filed within 2 weeks. Good stop. We find that this court, in its order dated 29/10/2025, had given a final chance to the state respondents to file their counter affidavit. Thus, considering the submissions made by the learned government advocate, we find that we find that in the interest of justice, the government advocate may be allowed to file their counter affidavit subject to paying a cost of rupees 5,000, which will be later deposited to the State Legal Services Authority. Yes. This is the matter immediately after the ensuing vacations.
Obligation.
Item number 4.
May I please your lordship? Lordship, I'm appearing on behalf of my senior Sanjay Kumar
Where are
Mehdi.
you? We don't see you. Yes.
Am I audible, Lordship?
Yes, now yes.
Lordship, I'm appearing on behalf of my senior Sanjay Kumar Mehdi. Lordship, yesterday we have taken steps upon respond number 4 to 11.
Okay, so we'll wait for the return, isn't it? Yes.
Yes, Lord.
Miss
R.
Saikia, learned counsel, appearing on behalf of her senior, Mr. S.K. Mehdi, learned CGC, for the applicants to come through VC, submits that they had taken steps for issue of notice upon respondents number 4 to 11 recently. Full stop. In view of the above, we may await for return of AD card from these respondents number 4 to 11. List after the ensuing vacations. Yes.
Obliged, Lordship.
Item number 5.
My lord, if I may be given 3 weeks' time for filing of written objection, my lord, in the
Who is
IA.
who is for the applicant?
My lord, I am appearing, my lord, for the applicant in the IA.
See, you all are not visible in the screen.
Something is
You can just hear your voice. Maybe you have not clicked this thing, that icon where the.
I think something is wrong here.
No, my lord. But
Okay,
I
okay.
can
Okay,
see
due
my-
to some problem in the connection, now we see you.
my lord.
So the counsel for the opposite party has prayed for time to file his written objection.
My lord, my lord.
Mr. Harish Gupta, learned
My lord.
counsel for the applicant slash appellant is present through VC, while Mr. H. Zodin Sanga, learned counsel
Private respondent, my lord.
for the sole,
1 to
for the
69.
respondents number 1 to
69.
69, has prayed for further time to file the written objection. In view of the above, list the matter after the ensuing vacation.
Much
Yes.
obliged.
Item number 9.
My lord, written objection has been filed by respondent number 1 to 3. However, for respondent number 4, service of notice has been not yet returned till date, my lord.
Okay, who is respondent number 4?
Badri Kala, it is legally wedded for the deceased.
What's the address?
My lord,
What is the address? Where is she staying? Respondent number 4.
address,
There should be a drive.
The director. When the deputy director notice has already served, is the director,
My lord, in IA, my lord.
oh, in the IA? Oh, okay, the first wife, Bahaduri
Yes, my
Khala.
lord.
AR Bazaar,
Happy Valley.
Happy Valley. Oh, that will be a little bit difficult. Happy Valley. Then we'll have to wait for some time.
Yes,
When
madam.
did you issue when did you take steps for issuance of notice? On which date? Quite recent? You don't have to take, are you required to take fresh steps? Not required, isn't it?
Let wait for some time, my
We
lord.
can still wait for some time. It was taken sometime during the month of August, September, October. We keep waiting, or you want to take fresh steps? How long are we going to wait? Okay, after.
But, let
Okay,
wait for
in
one
the
time,
next
my
court
lord.
date, you see whether you're required to take fresh steps. Because, okay, anyways, Ms. Zarim Sangpur, Lanet CGC, for the applicant is present, along with S. Vandal Sheta, Lanet Council for the respondents number 1 to 3. It is seen that the respondents number 1 to 3 have filed their written objection. Full stop. However, since AD card upon respondent number 4 is still away, is not returned yet, we may await for return of AD card from respondent number 4. List the matter after 4 weeks.
Obliged.
Item number 10.
May it please your lordships. My lord, in this IA, we are seeking a continuation of 10 days in filing the connected
Will allow?
writ appeal. My lord,
Mr.
Eugene Zoltan Moya.
Aldrin Zoltan Moya, learned counsel for the applicant is present, along with Mr. C. Zoram Chana, learned counsel for respondent number 1 to 4, and Miss
Sarah Lal Bensangi, respondent number 5.
Sarah so-and-so for respondent number 5. Let's stop. It is seen that the instant interlocutory application is for the condonation of a delay of 10 days in filing the connected appeal against the judgment and order dated 03/09/2025 passed by the learned single judge in WPC number 91/2023. Full stop. The learned counsels for the respondents submit that they will not have any objection to the condonation of the delay of 10 days. Full stop. Mr. So-and-so, learned counsel for the applicant, submits that the delay of 10 days in filing the appeal has been explained at paras 5 to 9. Okay, 9 of the application. Full stop. We have perused the reasons given for the delay and find that the delay of 10 days in filing the connected appeal was not due to any laches or negligence on the part of the applicant. Accordingly, we condone the delay of 10 days filing the connected appeal against the judgment and order, copy paste. Okay. And IA number 183 of 2025 stands allowed and disposed of.
Deeply obliged.
Now, in the main writ appeal, on the disposal of IA 183 of 2025, condoning the delay in filing the appeal, we have heard the learned counsel for the appellant, who submits that there are sufficient grounds for setting aside the judgment and order passed by the learned single judge in WPC number 92 of 2023, is it?
91 of 2023, my lord.
Yes,
91.
91 of 2023.
3.
What are some of the reasons?
Because the learned single judge did not accept our proposition in holding that age relaxations cannot be taken in a cumulative manner.
Okay, by submitting that,
In this writ appeal, my lord, our humble submission is that the learned single judge ought not to grant
that the learned single judge had erred in concluding that the respondents, the private respondents,
my lord, private respondent, sole private respondent.
by concluding that this sole private respondent was entitled to get cumulative benefits. Is it?
My lord,
Relaxation of, relaxation of 10 years altogether. 5
Had allowed
been Yes, my allowed. lord, my lord.
They
cumulative
contended that is-
benefits by relaxing, by allowing the relaxation of the previous,
a
it-
total of 10 years
the
relaxation.
previous, by allowing the relaxation of 10 years of the previous service of the private respondent. Stop. Is it?
no, my lord.
5
so-
years as a candidate belonging to a scheduled tribe, and another 5 years.
Okay,
as-
wait, it's too detailed, we have to study the case. Sufficient grounds to set aside the judgment and order of the learned single judge, since the learned single judge had not appreciated the facts and circumstances of the case in a proper perspective. Okay, full stop. Appeal is admitted. So can we list it for hearing? Both the parties are duly represented, isn't it? List the matter for hearing in due course.
After the ensuing vacation, my lord.
In due course, as per its own turn.
My lord. Deeply obliged.
Item 11.
Who's for the applicant?
Your Lordship, the counsel for the applicant Harish Gupta was earlier appearing in item 9, item 8.
Anyway, he's not here for this,
My Lord,
so-
this is the first time he has come up. They have recently filed. And
But someone has to be there. You're for whom? You're for the opposite
My Lord, I
party
just
or
want
for
to bring on
the?
record that no notice has been issued, but my name is given in the
I know. Anyways,
notice has not
but
been.
are you going to appear anyways? No.
We have to appear.
Find out, isn't it?
We have to find out, Your Lordship. No copies has been served.
None appeared, huh? Okay, so it appears that previously, before the withdrawal, you had appeared.
We had appeared, but since there were defect in their application, the appeal and the IA was withdrawn.
Okay, so
this
whether
is a
we are
fresh-
going to, okay,
this is a
yes,
fresh
yes,
appeal
yes,
and
okay,
the IA.
yes, okay. Anyway, they're just explaining the reason why your name was there. So it's only the application for condonation of delay that was this thing withdrawn.
Yes.
But in the writ appeal, you had appeared, you had filed the Vakaratnama.
Your Lordship, if I may, this is
Yes.
not maintainable in its present form and style, in as much as there was a previous IA and then it was withdrawn with liberty.
To file
But-
afresh.
But then now they are filing IA in the already withdrawn WA. Because the
Anyways,
WA was never
let the council be present. We will, because when he's not there, we cannot consider, isn't it? But since you're objecting to your name being this thing, we will mention that. Okay.
The WA, the 17th of 2024 was already withdrawn.
Okay. So let the council, whoever has filed the IA, explain himself, isn't it? He has to be heard. He's not here. Okay. Anyways, none appeared for the applicant on call, full stop. It is also noticed that though this is the first time the IA has been listed, however, the name of the opposite party, Mr. Jonathan, is it?
H. Gupta.
No.
Our name cannot be.
IA is here. So now where's your name in the writ appeal?
That is what, Your Lordship, we are submitting that earlier they have filed the writ appeal 17 of 2024 along with an IA for condemnation of delay before the division bench of this court. And since they were defect in the IA, the court they have allowed to withdraw the writ appeal along with the IA. It was granted, they withdraw the appeal.
But
to the
Ms.
IA.
Philo, the writ appeal 17 is before this court. We don't find any order of withdrawal here. The
There's another this
I
thing.
think the withdrawal was
Another-
only in respect of the
Where's
condemnation
the other thing?
application.
But Your Lordship,
So anyways, we will not do this thing. Since he is absent to explain himself, we'll just say since none appeared for the applicant, list the matter after the vacations. Just leave it at that. Then let them explain.
Item number 12.
We can't consider in his absence. Yes, what is the appeal about?
Your Lordship, this is a challenge to the order passed by the learned single judge, Your Lordship, of this Honorable Court, wherein I was directed to refund the deducted amount of 5,79,376 within 2 months to the respondent mind. The fact relating to this case, Your Lordship, is that the husband, late husband of the respondent, private respondent herein, Your Lordship, was earlier the senior branch manager of MRB, Your Lordship. During his tenure working as such, Your Lordship, he was alleged to have misappropriated certain amount of money from the bank amounting to more than 9 lakhs, Your Lordship. So he was after the disciplinary proceeding was drawn, Your Lordship, he was dismissed, Your Lordship. And after his dismissal, Your Lordship, his provident fund, which was earlier held by the Employees Provident Fund Organization, my lord, have been credited into his savings bank account, Your Lordship, under the Mizoram Rural Bank branch, Araizol, Your Lordship. So on that fund being coming into his account, Your Lordship, the authorities of the MRB, Lordship, in terms of their power, my lord, under section 30, regulation 39 of the regulation of the MRB officers, Lordship, had deducted and forfeited, Lordship.
How much? What is the amount involved?
The amount they had deducted was 5,76,376, my lord, as a part recovery, Lordship, of the loss caused by him to the bank, my lord. So he was aggrieved with that forfeiture deduction from his account. He come before this Honorable Court, Lordship. That was the short story, Lordship. And in coming to this court, Lordship, he had approached this Honorable Court only after almost 18 years, Lordship. So
What,
actually
18
there
years?
there
When was
was a
this order? Appeal
delay
was
of
when?
18 years, Your Lordship. Number one. So that 18 years, Your Lordship, he had not explained it in his petition, Your Lordship. He had not justified
So
how.
was that raised before the learned
My
single
lord,
judge?
yes, for that, my lord, if I may take Your Lordship to,
So
if
what
I
did
may
the
take
learned single judge say about the 18 years?
18 years silent, my lord, unfortunately.
But was the matter raised before the learned single judge
This-
regarding the
yes, Your
18
Lordship.
years?
If I may take Your Lordship to page 86 of the paper book, Your Lordship. This is the affidavit, Your Lordship, filed by MRB, the present appellant before the learned single judge. Herein, my lord, at page number 88, my lord, specifically at 88, paragraph number 2, Your Lordship. It is stated specifically herein that at the outset, I would like to state herein as a preliminary objection that the petition is bad for delay and laches, inasmuch as it is filed 18 years after the
Page, just come back. Page
88, 88, Your Lordship.
88, which line?
The first line, Your Lordship.
No, 88 here, is this the paper book? In your petition,
Actually, the writ appeal, Your Lordship, writ appeal.
pardon? Because it's an appeal against the judgment of the single judge.
Not getting.
This is- So now, in your writ petition, this page 88 is something different, that's what. Page 88 starts with "and disciplinary authority, Mizoram Rural Bank."
Actually, this is a writ appeal, Your Lordship. So, in writ appeal, I think paper book is
Maybe
not
it's
prepared.
87, just read again the sentence at the outset.
At the outset, yes.
It's page 87, not 88.
Oh, sorry. That's right.
Hmm.
87. In my copy, it's 88, sorry. At the outset, I'd like to so and so, Lordship. So, that issue has definitely has been brought out before the learned 12th.
No, but at the time when the matter was heard, was this ever raised? Let's see the judgment. Was this point one of the points to be considered? What was your submission? Para 5 of the judgment, page 4.
Para 6, so
No, para,
par
para
contra.
6. Para 6 is here this thing.
This is on the merit, my lord. On the merit.
So did you ever raise this issue? Did you ever make this
Raise,
submission?
Lordship. Definitely raise, Lordship.
You made the submission, but it's not been recorded.
Yes, my
Is that
submission,
one
my
of
lord,
your
was
points?
based on my pleadings, Lordship. It is already there in my pleading, my lord.
Your pleadings, but when you submitted the matter, a verbal submission, did you ever
And
raise
for that, my
point?
lord, if I may take a lordship to the operative part of the judgment herein, at page 8, it's in page 8 in my copy, maybe 7, my lord.
Now we.
Herein,
Huh.
herein, the learned trial, single bench, my lord, single judge, was very much aware, my lord. Here he
Where?
stated
Where
that,
is it?
this is para number 10, lordship.
Para number 10.
Yes.
Ah.
In view of the, I find merit in the writ petition and the respondent number 1 and 2 are therefore directed to refund that forfeited amount of so-and-so to the petitioner who is legal, so-and-so, so-and-so. Ordinarily, court would have considered imposition of
Yes.
appropriate interest along with so-and-so, so-and-so. But now, since the petitioner has approached this court after 17 years and therefore interest,
So there's
he
no
was aware.
limitation.
He was aware.
So he was aware and didn't find that 18 years is a delay because there's no limitation period for 18 years.
For
Anyways,
that, my lord,
now-
I have authorities to rely on, my lord.
Yes, okay, 18 years. That's your first point.
My lord.
Okay. Hmm.
And now, number 2, my lord. My main contention is that no provident fund account of the respondent has been forfeited, my lord. What is forfeited, my lord, is his normal fund, which was already credited into his normal saving bank account, my lord. So that no longer bears any birthmark, whether it may come from certain income or certain other income, or it may also be from the provident fund. But once they get credited into his normal account, there his normal fund.
Savings account.
Savings account, yes. There is no dispute regarding that, my lord. It was credited into his account, my lord. And the deduction, my lord, was made from his normal account, not from his provident fund account, my lord. That is an admitted fact. But unfortunately, my lord, the learned single judge, my lord, may be a little misconceived regarding that, my lord. Here, that can be seen, my lord, from the page number 2, the first page of the judgment, my lord, at paragraph number 2, my lord.
So it cannot be deducted from his provident fund.
Yes,
which-
that we
which-
admitted, my lord. That
which
is
you admit.
that
isn't it?
the Provident Fund Act itself at section 10, my lord, specifically said that Provident Fund account cannot be, my lord,
But you're
forfeited.
saying that you're appealing because it was not deducted from his provident fund, but from his
Exactly.
savings account.
Exactly, my
Oh,
lord.
okay.
Exactly. So here, my lord, the learned single bench might be a little misconceived regarding that, my lord. That may be seen from page number 2, which is the impugned judgment, my lord. Paragraph number 2, my lord. The short question involved in the instant case is as to whether the provident fund money of an employee can be forfeited for recovering alleged embezzlement.
Which
amount.
cannot be. That is.
Yes,
the
this,
accepted
my
fact.
lord, was never the question before the learned trial. We admit that this cannot be done.
Okay,
But
so
what
let's
our
see your
contention is-
submission. Let's see the submissions made by you.
My lord,
Para
my-
6, I think. Para 6 of the judgment.
submits that the amount that has been forfeited from the husband of the petitioner was the amount which was available in his savings account, normal savings account. That we have brought it clearly before the learned trial, single judge lordship. And not the direct forfeiture of the provident fund money. That was also my submission before the learned.
What was the amount in his provident fund?
Provident fund 5,76,000.
This is the exact amount.
Exact
Same
amount,
amount. You took
because
it.
because he was not having any other amount in that account, man. For yes,
So it is that money.
yes, that same money.
That money, it cannot go directly, they cannot directly interfere with the provident fund. Once it comes to the savings, this thing, that same provident fund amount was forfeited. Anyways, let the council further respond.
My lord. For that, my lord, if I have to, I
Page?
think your lordship, take your lordship to
Yes.
what does the Provident Fact, Section 10 of Provident Fund Act say, lordship? For that, my lord, if I may take your lordship to.
Okay, wait, we have noticed that at page 7 of the judgment, that submission which you have made, okay, has also been discussed by the learned single judge.
Yes, your lordship.
That discussion,
Yes, your lordship.
he has looked into that issue. Same amount from the provident fund, what we have just mentioned.
Same amount. Just because,
Because of that, it came to
just
that
because the amount is similar doesn't make it a provident fund, my lord. How, my lord? Because it already loses its color of provident fund. Once it is credited into normal account, I can use it
Okay,
for
okay,
buying
if you
a
have
car.
so many-
I can use it whatever, my lord.
But you admit that that is the exact provident fund amount,
Yes, yes,
correct?
yes.
And
I-
you
I
also
admit.
admit that under section 10, you cannot take it from the
I
provident
cannot take the provident fund amount, my lord. For that, my lord, I have to
Yeah, you
take
have
your lordship
some,
to
authorities.
Section 10 of the Provident Fund Act, your lordship. What
Okay.
is prohibited therein, my lord?
Okay.
It is clearly written therein, my lord. So
Let's see the Provident Fund Act, Section 10.
that is the misconception.
So
can
it's
be
only
there.
that point, whether the money which
Yes.
was in the savings account can be considered as Provident Fund or not.
It can also be more than that. It can also be less than that, my lord.
Exact
So,
amount, isn't it?
yes, because
So supposing,
why
no,
exact
no,
amount
let
is
me,
stated
let's
here?
get some clarity.
my lord,
Supposing now you wanted to deduct from the Provident Fund.
My lord.
Okay. Then the Provident Fund, where is it deposited? It's with the, can you go directly and take it out from the Provident Fund, deduct it? Or it needs to be first transferred into a savings account and from the savings account? What is the procedure?
procedure is, lordship, I can only take it out from their normal account. I
Only,
cannot-
no, then. See, supposing you wanted to deduct from the Provident Fund,
No, that cannot be deducted, my lord. That is protected by the law, my lord.
That's right. So what you could not do under the law, you've done it indirectly. This is why the single judge have
For that, my
allowed
lord,
the writ petition.
the law does not protect the fund already in the normal account, my lord. It doesn't protect, my lord. The act itself says, my lord.
so the Provident Fund cannot
If
be
I may read,
touched.
Lordship.
No, wait, Provident Fund cannot be touched, okay?
Yes,
So
I
it
admit
was
that, my
not
lord.
touched.
It is a admitted fact, my lord. It is a
But
law,
you're
my
saying that now it is not Provident Fund, it is saving account, so because of saving account.
Yes.
So no, just say, supposing. Now, when you say it cannot be touched, but you want to touch it, so you wait. The moment it is put in the savings account, you immediately seize it. Then where's the protection? Because sometime, at some point of time, the money which is kept in the Provident Fund will have to be transferred to a savings account for the person to use the money. Otherwise, he'll never use it. So you just wait like a cat, waiting for the Provident Fund to be transferred into the savings account, and then you snatch it. Then where's the protection?
Protection is during the time when it was still in the.
Anyway,
My lord,
let's see
that is why
10,
I'd like to
10. Yes,
take your
let's
lordship to this
get some
provision.
clarity. Section 10.
Section 10, protection against
What
attachment.
type of protection will it be? I'm just thinking. Anyway,
My lord, my lord. We have to be very clear. my
yes,
lord, I
that
think.
little thing we have to differentiate. Huh?
Uh-huh.
Protection against attachment.
My lord.
Okay, yes. Let's read
The
it.
amount standing to the credit of any member. My lord. It
Who's
talks about
member?
member, my lord. It doesn't talk about any fund in the normal account, my lord. Any member in the fund. What is the fund, my lord? We have to see what is the fund. my lord.
Provident Fund, okay. Huh?
Definition is there, my lord. What is fund? Definition clause is at section 2 here, my lord.
What is the definition?
What is the fund, my lord?
What is the definition of fund? Let's see, means Provident Fund established under the scheme, huh? So the Provident
Section
Fund.
2,
Yes,
Clause
Provident
H,
Fund.
my lord.
Huh.
Fund means the provident fund established under a scheme. What is a scheme, my lord?
So the fund is there, it's
Means-
protected. Huh.
Please kindly, my lord,
Yes.
go through
Please
this.
read.
Scheme means the employees' provident fund scheme framed under Section 5, my lord. Section 5 says, my lord, provident fund schemes, the central government may, by notification in the official gazette, frame a scheme to be called employees' provident fund scheme for the establishment of provident funds under this act for employees, my lord. Employees, my lord. So actually, it talks about the time when someone is an employee, my lord.
Okay.
Once they get superannuated, terminated, deceased, my lord, they no longer are employees, lordship. And the moment that happened, my lordship, that fund will get credited into their normal account for them to enjoy, my lord.
Okay.
Like, for example, my lord, if I
I'm
get,
getting your
I
point,
get to
huh?
get a petition, some payment from, for example, from, let's say, MRB. for my
I've got your
engagement, for
point,
example.
huh? The provident fund,
they
money
get-
is deposit, huh?
Yes, they get it, that money that they get it deposited into my account, my lord. Then once I get it deposited into my account and credited into my account, my lord, I can say I get paid, my lord. Isn't it?
Okay, fine, huh?
Do I make
I'm
myself
getting your
clear?
point, huh?
So
You're
I get
saying
paid.
provident
So
fund
I enjoy it,
remains-
my lord.
uh-huh.
The moment it is in my normal account, my lord, I have free hand. I can enjoy it. I can have it used for buying car. I can have it used for buying anything I want. Or I can have it saved therein to remain therein, my lord, in my normal account. So the moment it get credited into my account, my lord,
It's no
I can
longer
then-
provident fund. That's your point.
yes, your lordship.
Then
And
next.
not only regarding this provident fund, my lord. If I, for example, as I said now, my lord, if I get any payment from some organization, my lord, then the moment it comes into my hand, in my account, my lord, it's free now, my lord.
Next point.
If I have any other amount balance therein, it will
We've
mix
got your
up.
point. We have got your point. Provident fund is provident fund as long as it remains as provident fund. The moment it is put into the savings account, it is no longer provident fund. That is your point, isn't it?
Yes, your lordship.
So next.
So the fund itself
So
makes
this,
it very
so
clear.
read-
my lord.
read the section
so
10
the
to
protection,
explain.
yes, the
Read
protection,
section 10,
the protection get that we read through, my lord. In section 10 of that
Yes.
yes Provident Fund Act covers only up till, my lord,
Yes.
up till this Provident Fund scheme, my lord. Once the moment it get credited into some normal account, my lord, of
It is
the
no longer
beneficiary,
provident fund.
it is
Yes.
no longer, my lord. They cannot have it enjoyed it, my lord. The moment
So
it
just
get
read
into
to clause 2, 10 to
10 to, my lord.
section 10 to.
Clause 2, lordship. Any amount standing to the credit of a member in the fund or of exempted employee in a provident fund at the time of his death and payable to his nominee under payable. It is not paid, my lord. So it still is payable. It talks about the payable. my lord.
And payable.
Payable to his nominee under the scheme or the rules of the provident fund shall, subject to any deduction authorized by the state scheme or rules, vest in the nominee. So it talks about nominee, not the one who already get paid, my lord. It still talk about nominee. It still talk about payable, my lord.
Okay, and
So what this protection is given is only protection as long as it is in the
Mr. Counsel,
provident fund
where is
account.
this to communication? One of 9/11/2006 written by the Assistant Commissioner of Provident Fund, and the other one is
Yes, my lord.
15/12/2006 written by
That-
the Chairman,
that-
Mizoram Rural Bank.
My lord, my lord.
Where are
That-
these two communications? Where do we find these two
It
communications?
is here in my lord. It is there in the petitioner themselves had enclosed it, lordship.
Could not be done.
Since he had
Where is that page?
page 76 in my copy.
76.
Yes, your lordship. He had submitted a representation to the Regional Provident Fund Commissioner, your lordship, praying for their health, my lord. Saying, contending that
Next page,
that still,
next page, that copy.
contending that still is protected by law, my lord. He was of the belief, of the contention that cannot now be attached, my lord. That is the main basis why he had come before your lordship.
So your main point is, once it's in the
So-
savings account, it's no longer provident fund. That's, I think, his main account, which we have to see.
So regarding this, my lord, a reply was also sent by the MRB, lordship, page 79 of the writ appeal paper. 79, Annex 7. It may be 78 in your copy, lord.
See, these pages are not very eligible, very difficult. 79.
Yes, this is to the Assistant PF Commissioner, Sub-Regional Office, Laitum Cross Shillong.
80.
The other letter. Which said it should be returned back.
So this is also a letter, Employees Provident Fund.
Page 80.
No, the letter, it's from the Employees Provident Fund, all right, on
We inform-
on top, na, page 80,
And the 80, what is the second? He is the assistant PF.
working in the Employees Provident
Yes.
Fund.
He's also directed that in his
It should be returned.
that illegally forfeited to return.
You should be
Despite
returning.
this, it was not done, therefore the return was filed.
This is written to the chairman, Mizoram Rural Bank.
Yes, Your Lordship. For that, my lord, a reply was sent by MRB, Lordship, saying
Where's
that
their reply?
reply is 79, Lordship. Maybe 78 in your copy.
Because it's in the savings account. You got your
Yes,
point?
yes, yes.
Uh-huh.
Yes, it is stated that since
So we have to interpret this 10, section 10. This interpretation of
Yes.
section 10,
Yes,
which
yes.
according to you is that the amount is, what is protected as long as it remains within the
Provident fund
provident
account.
fund and not transferred to the savings account.
my lord,
That is his point.
that is
So
the sum and
interpretation, so, yes, so that's why I'm saying read section 10 again, the whole thing, so that we can understand properly as how you have interpreted section 10. The first is that to any member, so he's saying that he's no longer a member,
my lord.
isn't it, the first point? He should be an employee. The petitioner right now is not an employee anymore, so he's not protected. Yes, then?
So to fully understand that, that is why, my lord, I take your lordship to
Yes.
different provisions regarding this, regarding that, what is the fund as explained in section 2H, and what is the scheme, and thereafter, my lord, section 5 talks about provident fund, my lord, explaining what is the scheme. So the scheme is that is
Yes.
created by the central government, my lord. So actually, it taking in conjoint reading of lordship all these provisions,
Wait,
it
section
comes
5.
clearly, lordship, that the protection given by section 10 of this PF Act, lordship, is
It's
the
protected as long as it is within the, kept
My
in
lord,
the
my lord.
provident fund and not released as, into the savings account.
my
It's
lord,
as simple
exactly.
as that.
On the other hand, my lord, if it still keep on protecting the amount already credited into his normal account, my lord, that cannot normally thinking, my lord. Even if putting myself into his shoes, my lord, I cannot comprehend, my lord.
It is, it's a savings, this thing now. It's a savings account and not provident fund. Okay.
Unfortunately, my lord, now in his account, my lord, he is not having any other amount lying there at the time when this PF fund was credited into his account, my lord. That is there also in the order, my lord, order of that forfeiture, my lord. The MRB stated that since there is no fund lying idle therein, my lord, for deduction, my lord. So they cannot do, my lord. They
Mr.
cannot
Counsel,
deduct
is there
any more
provision
amount.
under the Act for recovery of one after the provident fund is credited to the account? Any provision for recovery if suppose that has been done illegally or because of by miscalculation?
Yes, for that, my lord,
Any provision?
there is MRB regulation, my lord, that says that recovery can be done, my lord. It was under regulation 9, my lord.
At that time, credited to the offense because his account they forfeited. Later on, he was acquitted by the
Okay. Because of that, they have come to the.
why after so many years.
Already released long time back. You'll have to see. Whether it's appropriate or not after so many years.
Nobody can touch because it's like a cash because it has not been released to the member.
So once it's in the savings, yes. What
That
is
is Regulation 39, Lordship.
Regulation 39.
Roman 4, recovery from emoluments or such other amounts as may due to him of the whole or part of or any pecuniary loss caused to the bank by negligence or breach of orders.
So in that dismissal order, anything was there for?
My lord.
Where is that order?
Yes,
Show us that. You're not
That is
showing what
the
is
one which
required
they
to,
have-
you're reiterating your submission only.
Yes,
Show us the main points. Where is that order?
the order is the one which they have challenged, Lordship. It's at page 74 in my copy, Lordship.
the one which is shown? no?
Annex 4. It may be 73 in your copy, Lordship.
Please read the
If I may,
portion.
if I read it, Lordship, if I may read. There is that second paragraph, Lordship, that begins with, in the said circumstances, Lordship. Is Lordship with me?
Yes.
In the said circumstances, it is essential on my part to make recovery for all losses caused by you to be recovered from you. Well, the aforesaid dismissal order was passed. You had no money in the bank to effect recovery whereby bank could not recover its loss caused by you for an amount of so and so, so and so. Now you have an account of an amount of so and so, which is available in our Aizol branch in the account number, saving bank so and so, so and so. Although we have filed a civil suit in the civil court of Aizol and prayed to pass a decree against you in order to recover the aforesaid amount, and you, in order to recover the aforesaid amount, and you have appeared to contest the said suit. A legal advice has been received by me to withdraw the suit and to proceed as per provision contained in general clauses, and as such, the following order is added in the original order of dismissal now. In exercise of my power as the chairman of the MRB, the disciplinary authority of the MRB, Officers and Employees Service Regulation 2000, this is a mistake, Lordship, 2000, instead of 2000, it has to be 2010, Lordship. And also in exercise of the power conferred in section 21 of the General Clauses Act 1897, I add herewith in the original order of dismissal that the loss caused by you to the MRB for an amount of so and so, which your amount of which is available with our branch in the account number SB 4813 standing in is hereby forfeited.
This is the only amount available in.
So this actually is part and parcel of the dismissal order, Lordship.
Where is that BC Chaturbedi's case?
My lord.
Give us that citation.
That is regarding the any upsetting of judgment regarding this disciplinary proceeding now. It is, I place that also, Lordship.
Where is
today.
it? So the amount of 5,79,000 and 376 was already forfeited, isn't it?
My lord.
Besides that,
So actually, my lord, the petitioners have failed to challenge the original dismissal order. Without challenging it, they only challenge the second part of order, my lord, only. So in that case, my lord, BC Chaturvedi comes into play, my lord, saying
So
that.
where is that? You give us that decision.
Yes, Lordship.
line this is.
I'll place this, Lordship. 1995 6 SCC 749. I place it, my. Paragraph 18, Lordship.
Paragraph?
18.
Could you see?
If I may read it, Lordship. If I may read, Lordship. A review of the above legal proposition would establish that the disciplinary authority, in on appeal, The appellate authority, being fact-finding authorities, have exclusive power to consider the evidence with a view to maintain discipline. They are invested with the discretion to impose appropriate punishment, keeping in view the magnitude or gravity of the misconduct. The High Court appellate authority to consider the penalty imposed or to shorten the is too severe, Lordship. He should have remanded it back to the disciplinary authority for reconsidering, Lordship. That is the way to do, man. Not substituting his own sentence, man. So actually, the original dismissal order also was not challenged hearing before Lordship.
But is that correct? Anyways, we'll have to hear the respondents also. Yes, okay.
Right now, if I may take Your Lordship to another citation regarding the delay, Lordship. Delay.
Okay, before that, the Provident Fund,
Yes, Your
when
Lordship.
was it transferred to the savings
Yes,
account?
for that, my Lord.
It was transferred to savings account
Yes, Your
when?
Lordship. Page number 73 of the writ appeal, Lordship. 73. This is annex.
This is on 9th October. The order. So when was it transferred? This page 73 is the
Letter by
written,
EPF to MRB, Lordship.
So this was on 9th October, isn't it? 10, 20, on top, the date of this letter for recovering of the said amount.
Yes, Your Lordship.
Way back in 9th October.
The check issued was 26.
26?
20th June, that means
Ah.
20th June 2006.
Okay. So it was sent to the same bank account on 26, 2006, and then it was recovered on by the bank on 10
October,
on the month of October. That is after about almost 4 months.
4 months.
So it was lying in the savings account for about 4
4
months.
months.
Okay. The money which was transferred. So you're saying that it is not Provident Fund now, it is savings account,
My Lord.
isn't it?
It has been lying there for quite a long time in his savings account also, my Lord. He
4
has not
months.
made use of it. He has not utilized it for his own purpose. Actually, the moment it entered in his true account, my Lord, he already enjoyed. He can be said that he enjoyed it.
Basic point, that is the only point.
He can be said he enjoyed it, my Lord. So there is the protection given by Section 10 of the EP Act, my Lord, doesn't
So that
extend
it was taken it. You've taken it.
to that much, Your Lord.
And it was already in account for about 4 months. Okay,
So,
fine. You
done
got
now.
your point?
Regarding that, the delay,
The
Lordship.
delay.
The delay. If I may take Lordship to 2000 volume 6.
Okay, so all this happened in 2006. Then when
2006,
was the
yes.
this thing writ petition filed?
Was filed in 2023, Lordship. 23.
2023. So this huge delay.
It was filed on 26th of September 2023. 26th of September 23. And the order they have challenged was order dated 9th of October 2006.
That is that page 74. Page 74 or page 73?
So now, if I may take Lordship to regarding that
2 pages.
delay in legislation, Lordship, if I may take Lordship to this 2006, I mean 2000 volume 6, 2000 volume 6 SCC 5.
2006, volume 6.
No, my Lord, 2000
2000.
Volume
okay.
6, SCC 562.
Okay.
Para
yes,
6, Your
yes.
Lordship. Para
This
6.
is, okay, you have mentioned when you gave this thing, your list, you mentioned 2006, not 2000. So they have wrong this thing, okay? Anyways, we listen, you read para what?
Paragraph 6, Your Lordship. If I may read. Apologies, Your Lordship. Apologies.
I still have it here. This is not working or what? Okay.
Apologies, Your Lordship.
Read para 6.
If I may read, Lordship. The order terminating the services of the respondent was passed on 28/1/1969. The writ petition was filed challenging the said order on 25/3/1975, almost after a period of 6 years. So this is a question of 6 years in the relied judgment, Lordship. 6 years. There was no explanation in the writ petition. No explanation in the writ petition whatsoever for this inordinate delay. The respondent sought for his re-employment in the corporation by his letter dated 191/74, almost after a period of 5 years from the date of termination of his service. It only indicated that he accepted the order of termination of his services, if not expressly but impliedly. In the writ petition, no ground was raised as to deprivation of a right of appeal to the respondent against the order of the termination of his services. It is not the case of the respondent that he was denied any opportunity offending principles of natural justice. An inquiry was held pursuant to the charge sheet. Witnesses were examined, and even the respondent examined 3 witnesses on his behalf. The inquiry officer, looking to the evidence brought on record, found the respondent guilty of the charges. It was also not shown that any prejudice was caused to him in the inquiry. The disciplinary authority, concurring with the findings recorded by the inquiry officer, after giving further opportunity to the respondent, passed the order terminating the services of the respondent. These being the facts and circumstances of the case, in our opinion, the learned single judge was right in dismissing the writ petition. We find that the order of the learned single judge is a detailed and considered one. We find it difficult to accept the observation made by the division bench of the High Court extracted above, that the order passed by the learned single judge was laconic, when there was no explanation whatsoever given by the respondent in the writ petition for delay of about 6 years. The learned single judge was right in saying so and dismissing it, when the ground that the respondent was deprived of a right to appeal was not taken before the learned single judge, either in the writ petition or in arguments. The division bench was not right in and justified in saying that the learned single judge did not assign any reason whatsoever in support of his judgment in this regard. We fail to understand how such a non-existing ground could be considered by the learned single judge, Lordship. Herein also, my Lord, if we go through the writ petition, my Lord, there is no explanation for the delay. No averments is made explaining, justifying the delay of almost 18 years, Lordship. Nothing is found. The writ petition is at page 31.
So the petitioner is the wife of the employee.
My Lord.
So when did he pass away?
He passed away
the main person, the employee?
only in, he had said it here, Lordship.
Because
2016, Lordship.
2016. So
2016.
10 years he
10
was not
years.
disputing over
My
the
Lord.
money
My Lord.
which was taken from his savings account on 26.
My Lord.
I think he had filed a representation.
But he filed
That
representation.
representation was filed when?
No, my lord. He also was convicted by a criminal court, my lord.
No, there was one representation, no?
Representation he submit only before the EPF commissioner, my lord.
Correct. Who had filed that representation? The petitioner or petitioner's husband?
Himself, my lord, himself.
He himself.
Before
had
he
filed.
died.
And
During
when
his
was
lifetime.
that? In
Yes.
2006.
2006, I think so.
Okay, before he passed away,
Before he passed away.
filed.
He also had not assailed the dismissal order also. He also had not assailed any order passed by the
So
criminal.
what is the representation? Let's look at the representation, nature of the representation. Page,
It's specifically regarding PF fund, my lord.
okay, regarding the fund only.
PF fund only. That I already shown you lordship earlier. Page. Yes, 76 lordship. Prayer to help in recovering employees' provident fund money. He's
Okay,
interested only in
okay,
the
yes.
fund money.
So then
76.
a reply to that was made, isn't it?
And no appeal, no statutory appeal has also been preferred before the MRB lordship.
No, page 76,
6 lordship. 6 in my
no,
copy, it might be 75 lordship in your copy.
75.
I don't know why this difference is there.
Oh.
70. Is the lordship with me now?
Okay, here also he's saying that it's just from a provident fund
Hmm.
and that,
Prayer to help in recovering employee provident fund money.
okay, same this thing. This
Same.
was in 2006, then he passed away
In
in
2016.
2016. Because the case was still pending, when was he acquitted from the criminal case?
Criminal, my
On
lord,
which year?
criminal order is here, it's enclosed here. It was disposed on 29 December 2009.
After he passed away. Okay.
No, my lord, during his lifetime, 2009. He passed away only on 16. my lord.
2016,
My
okay.
lord.
So disposed of in 2009, okay.
Page 52 in my copy, my
Yes,
lord.
yes.
52.
He was acquitted, isn't it?
No, my lord, convicted.
Convicted.
Convicted, my lord.
Okay, and sentenced? What was the sentence?
To the period already undergone, my lord.
Pardon?
To the period already undergone.
Already undergone. Okay, okay. Mm-hmm. Yes.
This is at page 52, Annex 1.
You can attach what is written in the front of the letter. Anyways, okay, so we have got a point 2016, and even after that, after he passed away,
My lord.
the wife did not do anything, and it's only much later, 2023,
My
that he
lord.
approached. So
That-
delay is one of your points. Huh?
My lord, my lord.
Okay.
And for that delay, my lord, apart from the earlier citation, my lord, one citation, if I may be allowed, my
By
lord.
relying on this is delay.
2021, volume 13, lords. 2021, volume 13, SCC 225.
So why have you decided to bring the big books when it is here? There was no current. Okay, because of the fluctuation. Good, good. Para?
2011, lordship. Well, if I may read, lordship.
Yes.
Well, it is true that limitation does not strictly apply to proceedings under Article 32 or 26 of the Constitution. Nevertheless, such rights cannot be enforced after an unreasonable lapse of time. Consideration of unexplained delays and inordinate lapses would always be relevant in writ actions, and the writ courts naturally ought to be reluctant in exercising their discretionary jurisdiction to protect those who have slept over wrongs and allowed illegalities to fester. Fence-sitters cannot be allowed to burst into courts and cry for their rights at their convenience, and vigilant citizens ought not to be treated alike. With mere opportunists, on multiple occasions it has been restated that there are implicit limitations of time within which writ remedies can be enforced, even though limitation does not explicitly apply, Lordship. Implicitly, implicit limitations, my Lord, will have to be considered, my Lord, regarding this. It is well settled that delay defeats equity.
Okay, fine.
Regarding my apologies, my Lord, regarding my earlier citation, my Lord, if that may kindly be placed before Lordship for this consideration.
2000,
volume
6.
6.
Yes, we have already read.
My
It was
lord,
here on the screen. We
my
looked
lord,
at
my
it.
lord.
Yes, yes.
So actually, those are the sum and substance,
2
my Lord,
points. Okay.
of my submission before Lordship. If the need arises, my Lord, if I may be allowed to rebut, my Lord.
Lordship, now that Learned Counsel for the Appellant has pointed out certain irregularities so far as the delay is concerned, I'd like to state that that is not the main question which is raised in this case. The main issue which has been raised is as to whether the Provident Fund can be attached, whether money which has been transferred from the Provident Fund office to the saving bank of the petitioner's late husband can be treated as free money for the purpose of attachment. So that is the moot question that needs to be answered by the Honorable Court in this case. So in the during the course of the writ proceeding, the matter has already been raised and set at rest by the Honorable Court. Lordship, the judgment and the order which is impugned is dated 18/10/2024. In fact, before that, I'd like to state that the deceased, that is the deceased husband of the petitioner, had died on 3/6/2016, and thereafter the matter was taken up by the wife, who is the petitioner, and that was as late as in 2023, that there is no denial. But during those days, after 2016, because of a number of difficulties faced by the petitioner, bereavement and difficulties in management of the family, and also crippled by the COVID-19 and all that. And as a result of all those things, she could not approach the court earlier. And as late as in 2023, she had approached this Honorable Court. Be that as it may, Lordship, my humble submission is that the matter has been finally adjudicated by the learned single judge by interpreting the relevant provisions of the Employees' Provident Funds and the connected CPC. Lordship, let me just go through the provision of this Employees' Provident Funds and Miscellaneous Provisions Act 1952, Section 10 again. Protection against attachment. 1. The amount standing to the credit of any member in the fund or any exempted employee in a provident fund shall not in any way be capable of being assigned or charged, and shall not be liable to attachment under any decree or order of any court in respect of any debt or liability incurred by the member or the exempted employee, and neither the official assignee appointed under the Presidency Towns Insolvency Act 1909, nor any receiver appointed under the Provincial Insolvency Act 1920 shall be entitled to or have any claim on any such amount. So the term or the phrase shall not in any way is important, Your Lordship. In any way means even after crediting that particular money to the savings account of the deceased, it still follows that it continues to be the provident fund of the deceased. So if the law says that it shall not, the amount standing to the credit of any member in the fund shall not in any way be capable of being assigned or charged, and shall not be liable to attachment under any provision of law, any decree or order of the court, or even under the order of the disciplinary proceeding. That includes. So, by extension of by making a kind of interpretation, Your Lordship, they have been trying to do what is impermissible under the law. They are trying to make that possible by circumventing. What is not permitted by law has been done in another way. That is prohibited. What is prohibited in law cannot and should not be done in any manner other than what is provided under the law. So that is the law laid down and followed in a number of cases. So in that particular case, in the instant case, in fact, this attachment was made immediately. Immediately means about three months after it was credited to the account of the petitioner's late husband. And it is exactly the same amount. Had it been 20 rupees less or a little bit more, then there could be some interpretation. But why the exact amount? It is not less and not more. The exact amount. There cannot be any other interpretation other than that it is, and it continues to be, the provident fund of the deceased. And in fact, being agitated, being aggrieved, he had filed the representation for giving him back, and he had waited for quite some time. In the meantime, he knew that he was convicted, and he had suffered a number of other disabilities also. He was convicted by the Honorable Court, and he accepted that conviction part. No appeal was filed by him. He accepted coolly. And then, so far as the other provision regarding attachment of that provident fund money, he was agitated. And then, by filing the representation, the question of he did not file an appeal as stated by the learned counsel for the appellant, though filing of an appeal may not be necessary, but the thing is that he did not accept that as it was, and then he had submitted his representation. And this was what is clearly reflected in paragraph 4.
Before you go to paragraph 4, under provision under section 10, what according to you would these words mean? The amount standing to the credit of any member in the fund.
Yes.
What is the meaning of
Standing
these
to the
words?
credit of any
Does it
member.
mean that something which is due to be credited or it is already credited? What does it mean? Because section 10 subsection 1 clearly indicates which is the amount which is there is a bar from attachment, there is a prohibition.
Yes. Yes, Your Lordship. The amount standing to the credit of any member in the fund. That means standing to the credit, Your Lordship, this is
Standing to the credit, that means it is not
Yes.
yet credited. It is
standing to the credit means which is belonging to the employee. Standing to the credit means it's a compulsory payment which was necessitated under law, and until unless it is returned to him, it continued to be standing to his credit. And it is the money which is due to him, and even if it is released to him, it continues to be the same money, the same fund. It is only that particular fund which is being released to his account. And Lordship, I don't know whether that is clear
Wait,
to you.
then the learned single judge had also interpreted that in
Yes.
para 9.
Yes.
You can just read para 9. Is this what you're trying to say?
Lordship,
Para nine of the
let
judgment.
me read it. From the above abstract, it may be seen that the amount standing to the credit of any member of the fund is not liable to be attached under any decree or order of any court in respect of any debt or liability incurred by the member. In the instant case, the impugned order provides that the amount that was forfeited is for the purpose of recovering the loss caused by the late husband of the petitioner to the Mizoram Rural Bank. It may further be seen that as per section 61K of the CPC, it is provided that all compulsory deposits and other sums in or derived from any fund to which the Provident Fund Act for the time being applies, insofar as they are declared by the said act, is not liable to be attached.
So this, as per section 21K of
Yes.
the CPC, where's that? All compulsory
60,
deposits.
section 60.
Which is deprived from any fund to which. So I think we have to see this. Because we're looking at this. You can elaborate on this, the reasoning of the learned.
Yes. 61K.
Because we have to basically see whether this interpretation of the learned single judge is correct or not based on this only, this parameter.
A Lordship, 60, if I take a Lordship to 60 CPC, section 60 CPC, this is attachment, regarding attachment. Property liable to attachment and sale in execution of decree. And all these are stated, and just below that, there's a proviso. Provided that the following properties shall not be liable to such attachment or sale, namely A, B, C, D,
So K.
K. All compulsory deposits and other sums in or derived from any fund to which the Provident Funds Act for the time being applies, insofar as they are declared by the said act not to be liable to attachment.
So all
So a conjoined reading of these two
deprived from any
provisions.
fund, including, so any
Yes.
deposit deprived from Provident Fund, could it mean that?
All compulsory deposits and other sums in or derived from any fund, to which the Provident Funds Act for the time being applies, insofar as they are declared by the said act not to be liable to attachment.
See, this is the reasoning. And then similarly, regulation 45 or 45, what is
2010.
this?
Regulation 45(4) of the regulation of 2010
Where's,
also does not permit holding back of any amount which is contributed to contributory provident fund. Regulation 45-4 of Regulation of 2010.
Execution of a decree. Anyways. Because this is all the
45-4.
reasoning that is given. It's read together. Mhm. That is the regulation called the RRB regulation, is it?
45-4.
This is a regulation. So now this regulation which is mentioned here, what is this regulation of the learned single judge?
Your Lordship,
Regulation 45-4. What regulation is
45-4.
this?
45 is regarding disciplinary proceedings after retirement. 45-4, subclause 4. Before reading subclause 4, if for the benefit of the Honorable Court,
But he said that it was mentioned, huh? So this 45-4.
may I read the entire 45?
Wait,
Lordship?
let us all be on the same page, no? This is 39, regulation 39. So one single judge has referred to 45. 45, yes, 45-4. Yes, please read.
45-4. The officer or employee against whom disciplinary proceedings has been initiated shall not receive any pay and or allowances after the date of superannuation, and also not be entitled for the payment of retirement benefits till the proceeding is completed and final order is passed thereon, except his own contribution to contributory provident fund.
So
So
he
this is also
exempts it.
accepted.
There is an exception.
The exception is there.
Except
Because
his
of the
own.
exception, other payments are prohibited
Shall not
except
receive
this
any-
provident fund.
So
So the-
provident fund contribution can be.
Yes,
Exemption, except that he's not to be paid. So that means provident fund is to be paid to him.
yes, yes.
Protects
It's
the
to be paid to
provident
him.
fund. So
Attachment is barred. And the finding,
okay, then read just so that we can all be clear. Okay. Now read Rule 39. Read Rule 39, subclause
Regulation
4.
39.
I'm sorry, Regulation 39. What you have just read. You have read 45, now come
40.
back to 39.
39,
4. Subclause 4.
yes, penalties.
Roman 4. Ah. They have done it
Subclause
under
4.
this regulation, this provision. huh?
The recovery from emoluments or such other amounts as may be due to him of the whole or part of any pecuniary loss caused by caused to the bank by negligence or breach of orders. This is recovery from emoluments
the loss.
or such other amounts as may be due to him of the whole or part of any pecuniary loss caused to the bank by negligence or breach of orders, except it has to be read in conjunction with this 45-4, except his own contribution to contributory provident fund.
Okay, so you're saying 39 has to be read with 45 and 45 protects, is
Yes,
it?
45-4. 45
Holding back of
subclause.
the contributory fund.
Yes,
Okay, that's his point. Okay, we'll have to see.
and as a result, Your Lordship, the learned single judge had deliberated upon and had said that similarly, let me continue to read, Your Lordship.
Yes.
Similarly, Regulation 45, subclause 4 of Regulation of 2010 also does not permit holding back of any amount which is contributed to contributory provident fund. Therefore, having regard to the protection as contained in the aforesaid provisions, it only appears that the amount which is forfeited from the provident fund money to be received by the petitioner's late husband has been wrongly
Anyway,
forfeited.
we all agree on this, okay? Provident fund cannot, we don't have to look into this, but the main crux now is whether this, amount which has been transferred to the savings account can be still be considered as the provident fund. Because it has been transferred now, the provident amount, that money, has now gone into the savings account. So once it's into the savings account, it can no longer be considered as provident fund.
That's true.
That's the main point, I think.
Yes.
Okay.
That is the
So,
case.
whether provident fund, that we all agree, provident fund is protected. But is it still to be considered as provident fund once it's been transferred and credited into the savings account?
You see, Mr. Lalram Zaba, because if the petitioner has a loan to pay, he can always utilize this money once this money hits his account. Is there a bar for him to utilize this money to pay his own loan after it is credited to his account? Certainly not. Once it is credited to his account, he shall spend this money as he desires.
That is true.
So
That is
if
true.
that is true, the same analogy will come
Your
here
Lordship,
also.
the thing is, the span of time, if it is not utilized within a span of 1 year, and if it is lying idle in his account, it may be said that he is not mindful of whether it is a provident fund or not. But the thing is that the deceased husband of the petitioner was not informed of the fact that it was returned. It was credited to his account earlier. But the MRB, the chairman of MRB, under which establishment the deceased was working, they knew it very well, and they watched.
Immediately
They
seized
watched,
the
yes. Immediately after it was credited,
4 months.
it was.
I think a notice was given from the civil court before attachment. There was a notice under section 80 of the CPC, I believe. Isn't it?
Regarding that,
The petitioner
Lordship, I have to see.
No. Zoram Chana.
Mr. Joramsana, I think some notice was received by
My
the
lord,
petitioner.
yes, actually, they, for the forfeiture of that amount, my lord,
Correct.
they earlier filed a suit, civil suit also.
But there that notice was
Yes. Notice was shown, that was served by the court also. But since they receive advice that is not not necessary, so they simply withdraw it again. So actually, they are well aware of it being deposited there. Number one. Number two, it's already there, my lord. There is no question of being that in and the act itself, my lord. Section 10 of the EP Act, my lord.
So had he immediately
It's very clear.
spent the money, he was
Standing
not
to the
barred.
credit, my lord.
You see, once the money was credited into your account,
Yes.
savings account,
It's a free money.
and you got to know about it, what you could have done was immediately taken that money out. Then you would have been saved from all this trouble.
3 months.
Yes, that could be.
But when was the notice issued then? Let's see.
It was not made known to me immediately, but when it was attached.
After it was attached, you got to
informed,
know
yes.
about it. Okay. When
And
was it
only
attached?
after that, I submitted my representation.
Where do you get that date? 3 months, Mr. Joramsana? You said 3
3 months, my lord.
Where did you get that?
From that, my lord, page number 72, my lord. This is intimation of that accreditation, my lord.
October
This was
2006.
in, the check was, the check
Where you-
was dated 20 June 2006. Please find it close.
And when was this money credited to his account?
June, he said.
Oh,
no?
June. This is the one.
It is
Okay.
in the
So-
month of June.
The deduction for feature was only in October, Lord.
Okay.
So Anyway, my lord, the length doesn't actually, once it
No,
is
because
there,
his submission is that we didn't know about this,
My
that it was credited to a savings account.
My lord, what is
They were
protect-
still under the impression that it was there in his provident fund. But then, once after it was credited, 3 months later, you had this thing.
My lord,
You seized it, isn't it? That's the main thing.
Section 10 speaks very clearly about this matter. The amount which is already credited doesn't talk about. It's lying credit to the credit any member of the
To the credit.
my lord. Standing to the credit means still in the provident fund account, my lord,
Not
which
released
may or
yet.
may not be credited. So it's not. It
That's the
doesn't
main thing,
talk
we
about
have to-
already credited amount. my lord.
Anything, sir? Anyway, anything else to submit? The only point is not whether provident fund can be released or not, that we are all clear, okay? Only thing is, once it's in the savings fund, can we still consider it as a provident fund? That's all. So interpretation of section 10 regarding whether it, once it is, can can the provident fund be still considered a provident fund once it's in the savings account? Any point, any other point to mention on that point? The senior counsel will just see.
Your Lordship, this K, section 60, K, 1K.
CPC is concerned at the
CPC.
time of execution of a decree, isn't it?
Yes.
So can it
Also.
still, will it be aptly applicable in this case?
Yes,
That
it was,
has,
it was
yes.
jointly considered.
It can, it's also applicable, okay?
And even the learned single judge had also considered this provision of
The
law.
CPC 60, okay. We'll have to examine that aspect also, isn't it? Yes.
Your Lordship, here, all compulsory deposits and other sums in or derived from any fund, to which the Provident Funds Act for the time being applies, insofar as they are declared by the said act not to be liable to attachment. So both the provisions work together and they need to be read
Read
conjointly.
together, okay.
Yes. And the section which we have just read out, the provision of Regulation
is clear
45.4.
enough. 45 has to be read with,
Yes.
again 39, you're
Yes,
saying, isn't
yes.
it? 39
all
and
those reading
Regulation
together,
45 have to be read together.
learned
Yes.
single judge had come to rightful conclusion that the money which has been transferred to the account of the petitioner's late husband continued to be the provident fund. Otherwise, there was, as also admitted by them, there was no other money other than the fund that has been transferred to his account. So that was the very money which has been attached. What was not permissible, even since as I said, the time gap does not make a difference. It may be 1 hour, it may be 1 year, it may be 2 years.
Okay.
So once it is found and proved that it is the money which is belonging to him as provident fund money, which has been credited back to him, so it remains to be the provident fund.
Okay, can you provide us any authority regarding this, except for your submissions and your interpretation made by both the
Lordship.
councils? Will there be any authority on this? We have to do a bit of research. Have you done
I'd like
some
to,
research?
yes, I'd like to make a further research on that, Your Lordship. So far as, this particular
No,
point
because
is
there could be
concerned,
some authority regarding this when it ceases to be a provident fund, can it be?
When the discipline is not completed, he shall not be able to receive this money, but he can only receive it
Later, so provident
can
fund
be
can
received.
be received.
But it doesn't mean that after he receives it, if there is any order passed by the disciplinary later of recovery, because suppose there is a loss, and they have to
They have to recover. He's recovered, so recovered from the money. But then, but he's saying that, account. But he's saying that the money which is in his account is still the provident fund. That is his submission. That's what, so now,
Lordship,
that's what he's saying. He's saying he needs time to research on that. That's it. We don't think it was, okay, so, see.
if I'm permitted, Lordship, I may be given at least 2 days' time.
No, 2 days this bench will not be sitting. Okay, but if you want to do a research on that, see, because we are quite clear now, after all your submissions, the only point which we have to be looked into is once it's credited into your savings account, can it still be considered as provident fund? The amount, everything is the same. The money is from the provident fund, but once it's released and deposited into your savings account, can you still insist that that is my provident fund? That point is the only thing, okay?
Yes.
Because otherwise provident fund cannot be attached. We are all clear on that. Now, if you want time to do research on that aspect, only on that. I don't know whether there'll be any judgment also on that, but we can give him time on that, only on that point. So
Tomorrow?
no, what do you say? Because we have to interview also. No, it'll have to be a different bench. But yeah, the points, you're both very clear now. So I think once it is placed before a different bench also, the point to be considered will be very limited. So they come prepared then. It cannot be part heard. Okay, it will have to be a different bench. Okay, yes. Heard Mr. Caesaram Chana, Learned
Before that
Council.
matter, if I may,
Yes.
You
also can do your research.
I have
to
done my
confirm.
research already, my lord. Actually, there is no specific definition regarding that from the citation, my lord. Actually, the act itself is very clear, my lord. If we carefully read, my lord, section 10 of the PF Act, my lord, that says any amount standing to the credit of any member means standing to the credit means it is still not credited, my lord. So the language is clear, my lord. And number two, my
But once it is credited, it is the discretion of that employee to spend it however he or she desires.
my lord. Number two, my lord. Regarding this CPC lordship, section 60, my lord, is
It's
specifically
concerning
regarding
the
execution of a
attachment.
decree. my lord.
Attachment.
There is no
that's
section. Yes, lordship. There is no execution of any degree for which attachment is made, my lord. And further, my lord, at this clause K, my lord, even though it says that derived from so and so, so and so, but
No, so
again now
protects the provident
go
fund,
back
no?
again to provident fund provision.
no,
So it's only strengthening, my lord.
So the provident fund, it's in his
It's
case.
all in the Provident Fund
No,
Act, my lord.
it's a provident fund as long as, so now his only point is that even though the money is in the savings account, it is still the provident fund because the amount, everything is the same. It cannot be savings, this thing. That's his only point. Now he wants time for research. We'll give you a short time because whether there will be any authority on that. Because your point is only that. That is
Yes,
the only
yes.
thing. Okay, nothing else. Provident fund cannot be credited. We are all clear. Cannot be this thing
How-
attached. We have
The
to
question will
clear
be
that.
how long this protection goes, my lord? Does it extend to the time when it's already credited into his
Yes,
normal
just
account?
after 3 months, it was this thing, same amount,
My lord.
same money. It's obviously the money from the provident fund, but can it still be considered as provident fund once it's in the savings account?
There is something on record to show that that is the only amount
Yes,
in the account.
That is
Yes,
there, my
that
lord.
is-
That
it was
is there
zero.
already. In the
that's
challenge
why.
order itself says that.
That is why
since-
instead of that 9 lakhs, which was the actual loss,
Yes.
this amount was
Yes, the
recovered.
only available amount, my lord.
Exact amount.
Yes,
So
because-
that has to be looked at. So we'll see. We'll give you time.
Because he doesn't
Because
have
we
any
know,
other-
we know that the money is from the provident fund. We are very clear about that exact amount.
Right.
But that money, can we still insist that it is provident fund or not? that point. We'll give him time.
Whether any
Because we are very
transformation,
clear that it is from
any
the Provident
transformation has
Fund.
taken place.
Okay, so see your research.
Yes,
this thing.
we'll do it.
Okay, yes. Learned counsel for the appellant also heard Mr. Cesar Ramchana, learned senior counsel, assisted by Mr. So-and-so, senior counsel for the respondent, assisted by Mr. So-and-so, learned counsel. Having heard the submissions made by the learned counsel's appellant, the learned senior counsel submits that he may be given some time to for further research to get some authorities regarding these his points submitted on whether the amount, the money of from the Provident Fund, once deposited into a savings account, can still be considered as Provident Fund. That's the only point.
Providence Fund as protected by Section 10 of the PF Act, madam. Thus, if that may kindly be, madam. Because
And
protection-
clarify the, to clarify
Protection. This means
Section
protection.
10, to clarify the intention under Section
Section
10
10.
of the Provident Fund. Act. Okay,
Employees
the
Provident
Employees
Fund
Provident
and
Fund
Miscellaneous Provisions
and
Act.
Miscellaneous Provisions Act
1952.
1952. In view of the above submissions, matter be listed, when you want it, not that this week, no, I don't think. Do you think
Lordship,
I don't think, after the
next week,
vacation.
Lordships will continue to sit next week.
No, this bench will not be available, so we'll make it after the vacations. Now,
Alright.
we have plenty of time to do it. After the ensuing vacation, yes.
No plans.
Obliged.
Item number 14.